And first, SB 131 will not have an adverse impact to the California court system. In the aftermath of SB 1779 by Senator Burton in 2002, close to 1,000 civil actions have been filed. During that time, less than 20 cases have been tried to verdict, less than 2%. Since a trial is the largest investment of time and energy in administering a case, this dramatically decreases the average court time required for such cases, thus decreasing the cost burden to the courts. SB 131 will result in a fraction of the civil actions the Burton bill did due to the narrow scope of the people that it actually includes. The bill only revives claims for people who were barred from using the Burton bill by a decision of the courts, and the Burton bill is far more comprehensive, so you can get an idea of the number of court cases. With far fewer cases in court time, SB 131 will not have a negative fiscal impact to the California court system. Secondly, I'd like to briefly discuss the argument that the SB 131 will impact public schools due to the closure of parochial schools. And we agree with our committee analysis that there is a litany of reasons why that parochial schools would close down. There is no direct connection between their closure and settlements of child sexual abuse cases. Besides not costing the courts or the schools money, it is our position that SB 131 will have a positive impact on the state general fund by shifting costs from the state to the abuser protectors. The cost shifting is outlined in a report that my staff has distributed to all your committee members. Child abuse victims are twice likely to become unemployed, fall below the federal poverty line, and use Medicaid as their sole source of health insurance. These are just some of the many indirect costs that are put on society's shoulder due to the heinous acts of a few. A civil settlement can bring closure for these people who were victimized, as well as give them the ability to get off public assistance. Okay. Since SB 131 is about helping victims, it always has been. Allowing these specific victims to seek justice will not hurt our state budget. In fact, it will help. Thank you, and I request SB 131 be sent to the floor where it deserves its vote on the policy merits. And we have some witnesses. Thank you, Mr. Chairman.
Let's go to our first witness.
Mr. Chairman, members of the committee, my name is Jeff Dion. I serve as the Deputy Executive Director of the National Center for Victims of Crime. And I'd like to begin by addressing the fiscal impact of this bill. As the committee analysis suggests, there may be an impact on state trial course costs by increasing the court's workload, but the analysis concedes that the amount of that impact is unknown. There have been numerous decisions restricting legal rights and access to the courts in the past years which have reduced the workload of the courts, yet the legislature has never considered those reductions of rights as the equivalent of an increase in available court funding. Conversely, any new action or increase in the statute of limitations can't be said to lead to an increase in court expenditures. In fact, civil court filings have consistently decreased according to the most recent data. Total civil filings decreased by more than 67,000 cases from 2010 to 2011. Unlimited civil filings decreased by more than 16,000 cases from in that period. So even assuming that a change in the statute of limitations or a new cause of action would result in at most a few hundred cases being filed, there'd be little or no impact on the state since the total number of cases filed has and continues to decrease. When California increased the general civil statute of limitations for civil cases from 1 year to 2 years, that bill wasn't even considered by Appropriations because the analysis found that it had no fiscal effect. Yet opponents would have you believe that altering the statute of limitations for one very narrow type of civil claim will have a significant fiscal impact. The Catholic Church would have you believe that more lawsuits would force them to divert resources from their private Catholic schools to survivors, and in turn force them to close Catholic schools. The effect would be an influx on students into the public school system that would cost California money. And while the church is correct that private Catholic schools are in decline, there's no logical connection between their closures and the lawsuits brought by the victims of child sex abuse. Rather, this can be attributed to a number of factors, including increased costs for Catholic schools, demographic shifts in inner-city parishes, and the rise of charter schools. Between 1970 and 1990, Catholic schools lost 75% of their religious faculty. And this has forced Catholic schools to hire secular faculty who demand salaries commensurate with their public school counterparts. And this has forced tuition at Catholic schools to rise, triggering enrollment declines and ultimately school closings. In the latter part of the 20th century, white Catholics participated in the mass migration from urban centers to suburbs. There were, for the most part, replaced by African Americans who are proportionately less Catholic. And this caused a dearth of Catholics in inner-city areas where parish schools were and still are predominantly located. But mostly, much of the collapse of the Catholic school enrollment can be seen as an unintended consequence of the charter school movement. Because in 2013, that academic school year, this marks the first time that more students were enrolled in charter schools than in Catholic schools. A 2006 study of enrollment dynamics of private and charter schools in Michigan found that for every 3 students gained by a charter school, 1 came from a private school. And as Father Ronald Newsy, the director of the Alliance for Catholic Education, put it, for the most part, when you offer an alternative to the mainstream public school free of charge, it can be a threat to Catholic schools which charge tuition. Now, unlike the illusory costs cited by the church, the fiscal impact of child sex abuse on public expenditures is very real. According to a recent report by the Center for Disease Control and Prevention, the cost of child maltreatment exceeds $124 billion. Childhood health care costs, adult medical costs, productivity losses, child welfare costs, criminal justice costs, and special education costs are all included in the direct societal cost for childhood sexual abuse. The CDC conservatively estimates the per-victim cost of these services at $210,000. Where death, including death from suicide or permanent disability, is the result of the abuse, such costs increase to more than $1.2 million per victim. Adults who are survivors of child sexual abuse are approximately twice as likely as those who are not abused to use Medicaid as their sole source of health care insurance. SB 131 can help shift those costs from the public to those who are legally responsible. The civil remedy in these cases also allows for a lien to recover the costs for services already provided to survivors. This bill would shift that financial burden where it belongs, with the institutions that have escaped culpability for decades by hiding the truth. And while one diocese in California filed a Chapter 11 proceeding after 144 lawsuits were filed against it, that proceeding was dismissed with the admonition by the bankruptcy judge, who was a devout Catholic, that the filing was disingenuous because the defendant's debts didn't exceed its assets, and warned others not to misuse bankruptcy to lowball deserving victims. This bill is a narrow legislation that revives these older claims, and it's simply a fix-it to comply with the Quarry decision by the California Supreme Court. Even the dissent in Quarry pointed out the absurdity of the conundrum that invited this legislator to fix that bill. SB 131 will shift that financial burden away from taxpayers to those who should be accountable, and lawsuits brought by these victims will expose perpetrators who are still out there because the institutions who protected them from exposure are still fighting to keep those dirty secrets secret.
Okay, we have a number of other witnesses. Let's go to the next witness.
John Lovell with the California Police Chiefs Association. We support this bill because we think it's smart public safety policy. If you look at many people who come to the attention of the criminal justice system and you look into their past history, you will find a pattern of abuse. This bill will enable those people to secure redress and secure the requisite treatment so that we are less likely to see them at the back end. We support this bill, and I just want to make one personal comment. I've been a Catholic all my life. I am a lector over at St. Philomene's. I find the argument that somehow this bill will result in the diminution of Catholic schools to be offensive and disingenuous.
Thank you very much. Next witness.
My name is Paula Treat. I'm testifying on my own today as an individual. I want you to know I was sorry I couldn't make policy. I'll try to keep part of this fiscal, double entendre. I was abused from second grade on. Had I known that you could tell, had I had my full memory before I was in my 20s of all the things that had happened, I would have told. And I will tell you that I go to sleep every night thinking about, had I been able to tell, other little children would not have been abused. And I wish it was only $200,000 I've paid in personal psychiatric care over the years to try and get through this. You never get over it, ever. And I'm ashamed of my church. I've been a Catholic all my life. And I'll tell you, to protect the pedophiles that are out there, they don't get better. They repeat. They repeat and they repeat. They simply move them from parish to parish. And the cost that costs individuals to have to go through that when this could be helped with this bill, I beg you to put this bill on the floor. Thank you.
Thank you, Paula. Next witness.
Thank you, Mr. Chairman and members. Aaron Reed. I represent the National Center for Victims of Crime, but I'm here to testify on behalf of PORAC. 64,000 members are pleased. You don't often see us at the same table agreeing with the police chief. Sometimes we don't. But I can tell you on this one, we totally agree. The officers on the street, the 64,000 members I represent, are strongly in support of this measure.
Next witness in support. Okay, the next witness is if we can just have your name and the group you represent and support.
My name's Chris Schrader. I don't represent anybody but myself. My abuse occurred between the years of 1968 through 1972. I've been living with this for 45 years. I did not know anything about a statute of limitations. When I finally came forward in 1990, after years of drug abuse and alcoholism, it destroyed my childhood. And it was an Episcopalian priest who was also a school teacher in the Compton Unified School District that finally got away from me when he was able to adopt a foster child in the system and take him with him. So I urge this committee to move this bill to the floor for the good of the children that are coming up, for my grandchildren, and for me to have closure with my life. Please support this bill.
Thank you. If we could keep the comments to your name and your position, and if you represent a group. Thank you.
Living Attacker, representing consumer attorneys, and we're in strong support of this bill.
Alice Kessler on behalf of Equality California and our 700,000 members in support.
Chris Lev Twombly with the California Association of Nonprofits. We're actually neutral on this bill. Wanted to distinguish our association, which has served the nonprofit sector for the last 30 years as a chamber of commerce, from the California Council of Nonprofit Organizations, which has taken an opposing stance on this bill. Thank you.
Hi, my name is Lana Grabarczyk. I'm an individual. I'm in support of SB 131.
I got it, Diane. Any other public comment in support? Seeing none, let's go to witnesses in opposition.
Chairman and members, John Norwood on behalf of California Council of Nonprofit Organizations, and we're opposed to this bill. We've spoken to almost every one of you personally with regard to the merits of this bill, so I'm going to be brief from that standpoint. Our client opposes this bill because we think it's simply bad public policy. The bill doesn't do anything to prevent or deter child abuse. It doesn't allow a plaintiff to go after the perpetrator under this bill and this new waive statute of limitation. It discriminates against victims, and it targets only certain from defendants and groups for which to bring a lawsuit. From from a fiscal standpoint, and to go back just for a moment, our organization does represent various religious institutions. It represents all the private schools in California, the private colleges and universities, the YMCAs, other charitable organizations, all of which will be essentially targeted by this bill. On the fiscal side of this, we believe the bill will result in substantial state costs in 3 areas, and a couple of those were addressed by the analysis. First of all, there are going to be additional fiscal impacts on the court system in California. It's impossible at this time to estimate that impact, from who knows how many cases that could be brought against there, and that will affect the already crowded court system. In addition to that, many of our organizations provide services to youth in this state, to underserved communities, everything from after-school programs to nutrition and other sports activities, things like that. All of these groups are self-insured for this kind of liability. All of them will have to at least take steps to put away dollars and contingency contingency reserve to deal with this potential liability. As a result, services are likely to be cut by those organizations, and increased pressure will be on the state, to provide those services. The other issue is schools in the state. There are many urban schools that are heavily subsidized by various organizations. Those organizations, again, self-insured for this, are going to have to put away funds that may well be the straw that breaks the camel's back and causes these schools to close down. For every student that goes from private school to public school, there's something like an $11,000 cost. So, those are, we think, the fiscal impacts. The proponents talked about the cost to society of this legislation, and the problem with their comments is that this bill only deals or targets private nonprofit organizations. That all the public schools, State of California, Department of Mental Health, Youth Authority, foster care program, corrections, et cetera, are all immune or exempt from this bill. As a result, those costs are going to continue. All the costs of abuse in the public school system, which studies show is 100 times more likely than by a Catholic priest, will continue to be foisted upon the public in the state unless this bill is amended or changed so that it actually does provide an opportunity for all victims. It doesn't discriminate against victims of the private sector. For those reasons, we urge your
Thank you very much. Let's go to the next witness in opposition.
Thank you, Mr. Chair and committee members. My name is Ron Reynolds. I am Executive Director of the California Association of Private School Organizations, CAPSO, a statewide consortium consisting of 20 private school service agencies and administrative units that provide service to some 1,400 nonprofit private schools throughout California. Those schools enroll approximately 400,000 pupils, or roughly 80% of the state's total private school enrollment. You don't see me here very often, the reason being that our organizational bylaws require unanimity among the members in order for CAPSO to take positions on pending pieces of legislation. But in this particular instance, there is unanimity, and there is unanimity among schools that are not only Catholic schools, but Protestant schools, Jewish schools, Islamic schools. We include every type of school from military academies to the Quakers and everything in between, including schools that have no religious orientation, hundreds of them, as a matter of fact. Mr. Chair and committee members, it's a sad day for California when the principle of equal protection under the law is rendered subordinate to a price tag. But that is precisely what you will be doing if you pass this flawed piece of legislation in its current form. For if you pass SB 131 as it is currently written, you will be advancing a bill that proposes to hold one employer culpable and another employer not culpable for precisely the same behavior. A bill that would grant redress to one victim and withhold redress to another victim for exactly the same cause. And you would be doing so for no reason other than it would cost the state too much money to see that all victims and all employers were treated the same way. And if it were otherwise, despite the representations of supporters, public schools would be included in the provisions, in the retroactivity provisions of this bill. We don't provide justice for some this year and for some more next year if the economy improves. If the retroactivity provision contained in SB 131 will not apply to all, it should apply to none. Senator Beall knows, and I want each of you to know, that at every step of this bill's progress through the legislature, our organization has offered to immediately withdraw its opposition if the provisions of the bill were made applicable to all schools alike, and I would certainly do so now. We would very much like to see SB 131 amended into a good law, one that doesn't draw distinctions between various classes of victims or employers, and one that protects all children, regardless of where they happen to attend school. But we must express strong opposition to a measure that proposes to create what amounts to two systems of justice. That's something none of us can afford, and I respectfully, therefore, request your no vote. Thank you.
Okay, we're going to go to public comment in support. Please state your name, affiliation, and I'm sorry, in opposition.
Thank you. Veronica Villalobos-Cruz with the Association of Independent California Colleges and Universities. We represent 75 private nonprofit colleges and universities in the state. The majority are non-denominational. We are opposed, and I would like to align our comments with CAPSO. Thank you.
Thank you. Additional public comment in opposition.
Gene Urban. I represent USA Swimming, which is the congressionally chartered National Governing Board for the Olympic Swim Team and Olympic Swim Movement. We represent over 300,000 swimmers and 10,000 swim clubs. We are opposed to the bill. Thank you.
Thank you. Julie Ball. I'm here on behalf of Kathy Barankin and her client, the YMCAs. If this bill were just about the Catholic Church, they wouldn't be here today in opposition. Thank you.
DeLacy from the California Catholic Conference in opposition.
Any other public comment in opposition? Let's go to finance.
We have a neutral position on this bill and do not estimate any fiscal impact.
Are there any questions or comments from this panel? Mr. Donnelly.
Senator Beall, I think you brought a very important issue to the forefront. And obviously, I think, as you hear the testimony of people from a lot of different quadrants, if you had made this apply to all schools, you would probably have a unanimous vote. So the question to you is, why are you only targeting private institutions and not protecting kids in every institution?
Well, I think the answer is several attempts have been made to do exactly that and have failed to achieve legislative approval. This bill, when it was originally introduced, and the bill that we have today is substantially different. The bill right now that was before you today only deals with one aspect of the original law that was passed in 2002, the Burton bill. That's SB 1779. 1779 was a statute that involved the civil liability of what we could generally call private institutions and other institutions. And I'd like to have some of our legal advisors explain that to you, okay? Thank you.
You may explain it briefly.
Good morning, Mr. Chairman, members of the committee. My name is Erwin Zalkin. I'm the senior partner of the Zalkin Law Firm. I have been in the trenches representing, or our firm has been representing victims in the trenches of courtrooms up and down the state of California for the past decade. I have the dubious distinction of being on the losing side of the Quarry case. I argued the Quarry case to the California Supreme Court. And I'd like to answer some of the questions that have been raised and to address some of the, I think, errors that the opposition has brought up with respect to the state of the law. First, there's been statements made that this bill, SB 131, would not apply to victims or revive claims by victims against perpetrators. And the problem with that argument is that it's not necessary because this state in 1994, in the version of SB of CCP 340.1A, made the age 26 or 3-year from discovery aspect of the bill against perpetrators retroactive.
And sir, I don't mean to interrupt you, but I think the question was not what you're answering. So if you could, if you're going to answer the question, then that's okay.
Well, I just want to correct the record on that. So with respect to the disparity between public schools and private schools, this is a revival bill. It would revive cases, a group of victims that were inadvertently omitted from the Burton bill in 2002. Actually, we all thought these victims were included. These were victims, older victims that were over the age of 26 and had not made a causal connection. We all thought they were included in the Burton bill. As it's turned out, and by the interpretation of our Supreme Court, they were not. They were not included. These were older victims whose claims were not revived by the Burton bill. This is what this bill is attempting to do. With respect to public entities, there have been significant changes in the law that do permit victims to proceed against public entities without having to go through the notice of claim filing requirement. That was changed in 2008. That's the protection for children against public entities. They are now covered by 340.1. They do not have to go through this 6-month filing requirement. They get the advantage now of the age 26 or 3 years from causal connection. They get that. There's a case called KJ versus Arcata Unified School District, which held that in older cases, victims who only now make their causal connection can proceed because that's when the claim accrued. They can now proceed with either the 6-month filing, if necessary, if it was pre-2008, or they don't need that anymore. So we don't need that right now. We do have those protections in place for victims of within public schools and public institutions. There's no reason that we have to bring that up in this bill.
Okay, I'm going to return now to questions or comments from the panel.
I'd be happy to answer other questions if you want.
Okay. Are there any other questions or comments from the panel?
Okay.
Ms. Harkey.
I believe we have a comment that's, I want some clarification from the other side on the same question, if I could have it, please.
Oh, okay.
Thank you, Assemblywoman. I just wanted to clarify that the Burton bill was not aimed at only private third parties. The Burton bill on its face applied to everybody, public school systems, the private and the state. What happened in 2006, I think there was a court case that said, although the legislature intended that, they made a mistake. They failed to waive the Tort Claims Act. And this was a case involving a public school that was brought under the Burton bill. And so that's the reason that prior to 2009 that it didn't apply to public schools. Mr. Simidian in 2008, on the heels of that decision, introduced a bill that was passed unanimously that does apply the Burton statute of limitations going forward in 2009. But we're not talking about cases from 2009 ahead. This whole debate is about those that were over 26 in 2003. And so if you're going to change the statute to fix what the courts did, then let's fix both courts' decisions. The intent of the bill was to apply it to everyone. And this steps back from that. It asks all of you to step back from your vote in 2008 to apply it to the public school system. That's what the bill does.
Any other questions or comments from this panel? Okay, Mr. Beall, would you like to close?
Yes, Mr. Chairman, I'll be brief because I think we had a thorough discussion, and I thank your indulgence for that. It's my belief that this bill has no fiscal impact on the state of California. That's what this committee is responsible for reviewing, and I think you can respectfully conclude that the fiscal impact on the state of California is minimal. We presented evidence that wasn't contravened by any other evidence from other sources that's true. So there isn't a fiscal impact. In fact, our Department of Finance indicated that as well.
That's right.
I think this bill deserves to have it presented on the floor of the State Assembly. I think defeating the bill in this committee, which is the Appropriations Committee, would be something that would deny the policy debate that needs to take place. So for those reasons, I request this bill be placed on the floor of the State Assembly and opportunity to take place to have a full debate on all the issues, and you can respectfully make your decisions. And thank you very much.